Hi, everyone. Welcome to today's class. I want you all to feel comfortable, even if you've never studied law before. Today's session will break things down in a very simple and clear way. We're going to take an exam-style scenario about a man named Victor and understand exactly what offenses he may have committed. We'll go through paragraph by paragraph so you can see how a high mark answer is built. Let's begin with the first paragraph. First paragraph explains the basic law on blackmail under Section 21 of the Theft Act 1968. It tells us that blackmail has three elements. There must be a demand, there must be menaces, which simply means a threat, and there must be an intention to gain something or cause someone a loss. The paragraph explains that menaces are judged objectively. This means the court asks what a reasonable person would think of the threat, not whether the victim themselves felt scared or not. This shows the clear line between law and morality. The cases used here help define that in R versus Thorne, the court said a menace can be more than just physical threats. It can include emotional or reputational harm. In R versus Callister and Warhurst, the court added that any kind of pressure on someone can count. And R versus Harry confirms that the defendant must intend to gain something like money. So the first paragraph builds a legal foundation for understanding what blackmail requires. Okay, moving on. As you can see, in R versus Thorne, the court clarified that menaces could include threats other than physical harm, such as emotional and reputational damage. This is reasonable grounds for a lawsuit in the court of law. R versus Callister and Warhurst further established that menaces can take form of any threat as long as it pressures the victim to act. And then here, I've underlined the cases. As you can see, this is very important for your exams. If you don't or you forgot to underline the cases, it may affect in less awardation of your marks. Okay, moving on to the second paragraph. The second paragraph applies those rules to Victor's first act. Victor demanded £200 from John and threatened to tell John's employer that he didn't have a driving license. Losing his job is a serious consequence. So this clearly counts as a menace because the test is objective. The fact that John didn't actually believe Victor would do it doesn't matter. Victor wanted to gain £200, so the intent element is unsatisfied. The paragraph then moves on to Victor climbing over the football ground to avoid pain. This is analyzed under Section 11 of the Fraud Act 2006, which covers obtaining services dishonestly. The case of R versus Sofrino confirms that entering a venue without paying is dishonest. So the second paragraph concludes both the offenses, that blackmailing and obtaining services dishonestly, are seen to be made out on the facts. Also, as you can see, as it says, the threat is assessed objectively. So John's disbelief in Victor carrying out the threat is not relevant. It refers to that the menaces can extend beyond threats of physical violence. You could also apply another case, which is entitled R versus Tomlinson, and you could find in the law teacher website, something I've used to conduct my answers. Okay, moving on to the third paragraph. The third paragraph looks at possible arguments Victor might try to use and explains why they fail. He might say that there was no blackmail because John didn't believe the threat, but Tracy versus DPP makes it clear that blackmailing is complete as soon as the demand with menaces is made. It is also a continuing act. I have not mentioned another case here because it might look more confusing, but there's the case called R versus Hester, which clearly outlines that blackmailing is a continuing act and continues until the demand is withdrawn. Okay, moving on. Victor might also say he had reasonable grounds because John truly didn't have a license. But R versus Harvey says that even if the underlying issue is true, using threats to get money is still blackmailing. For the football match, Victor might claim climbing over the wall wasn't really dishonest, but R versus Allen confirms that knowingly avoiding payment is enough to be guilty. So this paragraph shows all the leeways Victor could use for a potential defense. However, these potential defenses are weak here as the evidences are piling up. Okay. The final paragraph here shows the conclusion and what Victor is likely able to get as a sentence and whether he is guilty. It concludes that Victor is likely guilty of blackmailing because he made a demand, used a threat related to John's employment, and intended to gain £200. It also concludes that Victor is guilty of obtaining services dishonestly because he intentionally entered the football ground without paying, The paragraph also notes that his defenses, such as John not believing the threat or Victor thinking he had reasonable grounds, are unlikely to succeed. So the answer ends with a confident statement that Victor would likely be found guilty of both offenses in a court of law. The jury is also likely to be convinced by this, as the factual evidence that is presented in the court is very convincing. It is not just legally correct, it is also morally correct in the standpoint of the jury. And that completes the full breakdown of the answer. By understanding how each paragraph works, you can see how to build a clear, structured, high mark awarding response to a criminal liability question in paper 2. Thank you.